Hey, my name is Robert Chelle with Chelle Law, and my law firm assists physicians with employment contract issues. Today, I'm going to have a broad topic discussion, and it's what can a physician negotiate in an employment contract? So, the short answer is everything. It ultimately depends upon the willingness of the employer of whether they're willing to actually negotiate terms or not. I find big hospital networks are less likely to make major changes in an employment agreement, whereas if a physician's looking into a position with a smaller physician-owned practice, there's much more leeway for major changes. So, what are the things that are important to the physician, and then what are the things they can actually get changed? So in my mind, when I'm talking to a physician, I think the things that stick out as most important would be signing bonus, relocation assistance, how to terminate the agreement, making certain there's without cause termination that's a reasonable length, compensation, productivity bonuses, and then the non-compete. And then tail insurance as well. Who pays for tail insurance if it's a claims-made policy? So let's kind of go through each one of those and come up with some tips of how to negotiate. So first, as far as compensation goes, the physician needs to know their value and what their specialty's value is. Getting the MGMA data is helpful. Talking to colleagues about what they're being offered or what they're currently making in different organizations is helpful. Sometimes the associations for each specialty can provide information as far as what's a normal salary in your specialty. So that's one way to look at it. As far as productivity goes, this is a little more difficult. It's going to be completely based upon, I guess the arrangement. Is it kind of a hybrid of a base salary and RVU production? Is it a base salary and net collections? Is it all RVU? Is it all net collections? This one is really dependent upon what's the type of structure. If it's net collections, if it's a hybrid model, meaning you're getting a base plus a certain amount. Let's say, for instance, if the expectation was anything over, the collected over 20,000 by the practice, then the physician will get 15 to 25% of that. That would be a normal percentage. If the physician is purely on net collections, somewhere between 40 to 45% is pretty standard. As far as RVUs go, two things you can negotiate: the threshold, so meaning how many RVUs do you have to generate in order to get a certain amount, and then the compensation factor, which is the monetary value associated with the RVUs. That has some leeway as well. As far as signing bonuses and relocation assistance, the main things are the actual number, obviously, but then more importantly, what's the repayment schedule? Almost every contract is going to have some kind of forgiveness period, meaning if, let's say, the physician gets a $20,000 signing bonus and the initial term of the agreement is 2 years, then usually they'll have to stay for that 2-year initial term in order to have the entire $20,000 amount forgiven, so they don't have to pay anything back. Same goes for the relocation assistance. Relocation assistance should be somewhere between 10 to 15,000. Signing bonus can vary pretty widely, from 10 all the way up to 75. That's one's pretty specialty dependent. As far as non-compete goes, this does vary state by state what's considered reasonable. There's a few states where it's completely unenforceable, like California and New Mexico, for instance. Normally, the non-compete shouldn't be any longer than a year, and the geographic restriction should be somewhere between 5 to 15 miles from your primary practice location. Where to negotiate with this? Obviously, the length. You want to keep it 1 year or shorter. You want the non-compete to only apply to a few locations. There are employers who will say the non-compete attaches to every facility we own in the entire city. And so instead of having one office with 10 miles, you could have 30. So that's very important. And then specialty as well. Some specialties can do multiple things. So like, let's say you're in internal medicine, and you can be a hospitalist, you can go into family practice, you can do urgent care. If the non-compete states you can't practice medicine within that geographic restriction, well, then you're out of luck. Whereas if you just keep it to the specialty of what you're providing to that employer specifically, in this case, let's say you're a hospitalist, then you could go in, family practice or do urgent care for a year, and then when the non-compete ends, go back to being a hospitalist. That's something to think about. And then malpractice insurance certainly is always kind of a big discussion with my physicians that I'm working with. So one you need to identify, is it a claims made or occurrence-based policy? If it's a big hospital, they might be self-insured. And then after you determine what type it is, if it is a claims made policy, then tail insurance will need to be purchased after the contract terminates. And then who pays for that? So most of the time, if you're in like a small private physician-owned practice, the physician has to pay for tail when they leave. If you're with a big hospital network, you almost never have to pay for tail. Now, tail insurance usually costs about twice what your annual premium is. So let's just say you're in family practice, your malpractice annual premium somewhere between $6,000 to $8,000. So if you had to pay for tail somewhere, $12,000 to $16,000. So that's one thing that you can negotiate. Who pays for tail? Sometimes an employer will put, if you've been with us for 1 year, we'll pay for a quarter, and then 2 years half, and then 3 years 75%. So there's some ways of getting out of having to pay the entire amount. Just kind of have it dependent upon the situation. Now, the first thing that I talked about was, is the employer willing to negotiate or not? There will be some employers that simply say, this is a take it or leave it deal. I don't think those employers are going to be great to work with moving forward. If an employer is not willing to budge on anything, they likely will be difficult to work with going forward, meaning they're not going to accommodate the physician in some way. So I caution any physician who has been given a job offer. We ask for some clarifications or from, some certain concessions, and they just simply say, absolutely not. This is it. That's usually a red flag. And I tell the physician, you may want to continue looking for a job because this might not be a good fit for you. So anything in the contract is negotiable. You need to figure out what's most important to you. Sometimes a non-compete is absolutely the number one thing. For others, it's the compensation. For others, it's not having to pay tail. So it really is dependent upon the physician's wants and needs, and then tailoring kind of the negotiations to get them to that point. Well, hopefully that was helpful. If you have any questions, you can always call us at the phone number listed below in the description, or you can reach us through our website, ChelleLaw.com, CHELLE law.com. Again, my name is Robert Chelle, and I appreciate you watching the video. Thanks.